So, Lucy Connolly, what really happened behind the scenes? At the risk of sounding a bit BuzzFeedy, the answer may surprise you, because certainly it did me a little bit. To avoid all the clickbaity, sort of wait till the end, what am I surprised about? It's the fact that the being remanded in custody element didn't feature at all, it appears, in any of the discussions or in the appeal. So that doesn't seem to be a factor. But what I thought I'd do now is do my impressions of Aliens 3 rumour control, because I know lots of people have strong opinions on this, and quite understandably, but there seems to be a lot of misinformation out there about what actually happened and how the circumstances of the plea came about. So I thought if I could explain that gives a little bit of context for when people are discussing things further. So to get back to where this started, it's all about the tweet. You may have seen it, but I'll just briefly read it now because this is what she was charged with. She sent a tweet. She's got 9,000 followers, and she sent this following tweet: "Mass deportations now. Set fire to all the flipping," she didn't say flipping, "hotels full of the B words for all I care. While you're at it, take the treacherous politicians and government with them. I feel physically sick knowing what these families will now have to endure. If that makes me racist, so be it." That actually been seen a few hours later 310,000 times and reposted 940 times. She was arrested on the 6th of August, by which time she had actually taken it down. There were some other tweets that gave context, but she wasn't actually prosecuted for any of those, but they were going to use those as evidence to show her state of mind. The other problem was, perhaps for her, that when this all came to light, she actually went on to say to sort of various people, and it's not in dispute, she said, well, if I'm arrested, I will, quote, play the mental health card. Her husband and another third party suggested she take it down. She did. She was interviewed under caution after arrest. She admitted she'd posted the tweet. She said that her own child had died in horrendous circumstances, and the stabbings of the children in Southport had put her into a rage. She said she felt hatred about the incident and the circumstances, not about race. She said she had taken the post down because she realised it was wrong. Later in the interview, she said that her tweets were not racial and she had no intention to cause hate or racial issues. So that's the sort of factual nexus for this. So she was subsequently charged. She was held in custody and appeared before a magistrate's court, initially via video link. And then her case was immediately sent to the Crown Court, where she appeared in person for what we call a PTPH, Pleas and Trial Preparation hearing. Now, the offence she was charged with, Section 19 of the Public Order Act 1986, it says the following, and this is going to be very relevant, so I'll link to all this anyway so that you can read for yourself. But Section 19 says, a person who publishes or distributes written material which is threatening, abusive or insulting is guilty of an offence if A, he, and obviously he or she, intends thereby to stir up racial hatred, or, and this is the clincher, B, having regard to all the circumstances, racial hatred is likely to be stirred up thereby. So you'll see there that the actual single offence has two elements to it, and this is going to be, they're contained within one thing. So you are just prosecuted under Section 19, but there are two ways you can commit the offence, and it's very important because one way of committing the offence is, yes, I intended to stir up hatred, whereas the other one is, well, actually I didn't intend anything, but objectively speaking, bearing in mind when it was posted, the circumstances, what was going on, and my words, then okay, it's reasonably foreseeable. Yeah, I should have known that actually that would stir up racial hatred. Now, at the first appearance, she wasn't actually arraigned. She wasn't actually asked to put in a plea. The matter was adjourned. Again, she was, though, remanded in custody, but it was put over so she could get a pre-sentence report and a psychiatric report. But she'd spoken to her solicitor. She had a duty solicitor initially on the first appearance, and also the same solicitor later. And looking at all the notes, it's very, very interesting, because you would wonder, it's like, would you put in a basis of, if you're going to plead guilty to this, and I've discussed this before, we have what we call bases of plea, where if you are going to plead to something, normally you would put in a basis of plea and you would say, yes, I accept I'm guilty of this offence, but these are the circumstances, and then you would see if you could agree that with the Crown. because obviously, whether it's Section A or Section B, or subsections, that makes a huge difference. Did you intend to do this, or was it just an unintended consequence? Because obviously that would make a huge difference to sentencing, because this is all governed by the sentencing guidelines. And I know people are saying, oh, why was the book thrown out? The judges are bound by the sentencing guidelines. And all these, yes, and they are very lengthy sentences, just for quotes, hurty words, as people say, but these were all established back in the 2011 riots. Where people were literally just putting Facebook messages going, and a lot of that was just like, hey, let's pop out of town, have a good time. And people were getting multiple year sentences for that, because they were saying, well, with everything that's going on, at any other time, this might not have been a big deal, but because of everything going on, the fact that people were attacking hotels and there was public disorder outside hotels, I said that's obviously clearly a relevant factor. And I don't want to discuss the Ricky Jones case too much, because Dan's done quite a good video explaining the difference between the two offences. But I will I'll briefly mention that at the end, if I remember, which, as we all know, I'm not very good at. So anyway, her solicitor sits with her, and he goes through and he explained to her, and this is all recorded, and indeed Lucy Connolly herself had written an endorsement accepting that this had all been explained to her. And he said, look, there's two offences here. There's and if you are potted on the first one, the starting position is the 3-year sentence. Shall we discuss a basis of plea? But it was explained to her that if the Crown didn't accept it, and it apparently indicated the Crown said, no, we're not going to accept it, we're going for the main one, then they would have to what we call a Newton hearing. Because this is a rather strange thing. Had these been two separate offences, she could, for instance, have said, well, I'll plead guilty to the non-intentional offence, but I'll go to trial on the intent thing. And then, if she was duly acquitted, she'd just be sentenced on the basis of the one she'd pleaded to, and she'd get the full credit for pleading guilty at the earliest opportunity. But if you have a Newton hearing, then that's just decided by a judge. And I've done a full video on Newton hearings, which you can always just search in the channel for. But essentially, if you have a Newton hearing, you're saying, we dispute the basis the Crown are putting this. We accept we're guilty of the offence, but not on the basis that the Crown put it. But then it's up to the judge, and you can call evidence. And the judge hears the evidence, but it's not done in front of a jury. The problem then is, because you're pleading guilty, you obviously get credit for pleading guilty. But if you have a Newton hearing, and you lose the Newton hearing, you can actually lose some of that discount. I mean, usually they say 50%. Now, I've explained before, if it's just a quick one, where it was sort of, I agree you have done some shoplifting, but I'd only nicked £50 worth of stuff and £100 worth of stuff, and it's just a quick, let's look at some receipts, then the judge might not hold it against you. They sort of go, well, actually, I do find there was £100. They might not make a big difference there, but for something like this, theoretically, so she could have lost the credit. So plead guilty at the earliest opportunity, get the 1/3 off, have a Newton hearing, and then plead guilty when the judge comes against you, you'll get 1/6 off. When you're looking at sort of quite lengthy sentences, I mean, this can make, months inside difference. But what was strange is she said she didn't want a basis of plea putting forward. She didn't want a basis of plea putting forward. She said, I will just plead to this. And it was explained. It was explained to her that if you plead to this, you're looking at, a starting point of 3 years. The psychiatric report, the PSR came back. Apparently it wasn't particularly helpful. I've not had sight of the pre-sentence report, but they said it didn't particularly help, other than she just reiterated, I was very upset, death of my child, all things. And this was all taken into account. The judge said, I accept, the personal mitigation. Didn't accept it as a justification for the tweet, because what he said is, well, look, if you care about children, you could have put something out saying, these poor kids. He said, you didn't actually post anything supporting the Southport children. You just posted saying, this is all terrible, go to the hotels. If you just sort of, most simply like these poor children and linked it back to that. So the judge was, it's probably fair to say, a bit sceptical. But, he said, you've had tragedy in your own life with the loss of your very young child some years ago. I've read the psychiatric report from 12 years ago, so the psychiatric difficulties you then suffered, because there's a pre-existing psychiatric report. There's no recent psychiatric evidence. And whilst you may well have understood the grief of those who suffered, their understanding, their losses so that you did not send a message of understanding and comfort, rather an incitement to racial hatred. So again, they didn't rely too much on the further reports, because it was basically, well, yes, she's clearly upset and grieving, and this was something that would have an impact on her life, but it didn't actually go to the offending. Because, like I say, when you put in evidence like this, you're either arguing this is the reason I did the offence, so therefore take that into account as to whether I am guilty or in mitigation. Or it can be just general mitigation. I've had a terrible tragedy in my own life, please take that into account. But that doesn't actually have too much mitigation, because it's like, well, yes, some people have sad lives, but that doesn't really, affect the sentencing. You did what you did, and unless it's actually causative, it's not particularly relevant. There were some criticisms because the appeal was done by counsel, and counsel actually did try to criticise the solicitor. And the criticised said, well, what you should have done is, regardless of that, you should have put in submissions and said she's pleaded guilty, but she's only pleading guilty on the basis that it was non-intentional. But the Court of Appeal rejected that criticism, and I think quite rightly, because what they said is, the rules say you can't do that. If you're going to put in a basis of plea, you have to try to do the written basis of plea thing or the Newton hearing, because you can't just go in there, because it was accepted by not putting in a basis of plea that she was pleading guilty to the intentional offence, and therefore to argue, yes, she's pleaded guilty to the intentional offence, but she's not actually guilty of that offence, she's guilty of the other one, would be professional misconduct. So I think the Court of Appeal were quite right to reject that. So basically she'd pleaded, she got the credit for pleading at the earliest opportunity, and the judge followed the sentencing guidelines. I mean, they did say the judge perhaps overemphasised the aggravating features and underestimated the mitigating features, but the Court of Appeal said, well, no, we think the judge did, and there's a lot of discretion for judges. They said, the judge was right to take into account that there's all this background going on, and he did take into account her own personal circumstances, the fact that she did delete the tweet later on. But like I say, part of the problem was they were background tweets that pretty much emphasised, where she was joking about this. There were other about, that clearly had a racial component, where, she'd commented sort of about Somalis and people like that. And it probably didn't help that there was the I'll play the mental health card one. So yeah, so that's where we are. So I see people are criticising the solicitor, but the fact is, the records show, and Lucy Connolly signed these, so there's no dispute this was the advice that she was given. The duty solicitor did say, look, you can, we could put in a basis of plea on this. There never seems to have occurred to sort of just say, go fight it. Because actually, as a matter of law, she probably was guilty of the offence. Now, and I'll come on to a lot more personal, but should she have taken the punt anyway and risk going to a jury trial? Because, juries can return any verdicts they want. And even if a judge says, well, look, all the elements of the offence appear to be made out, ultimately it is still a matter for you, because this does tally with the Ricky Jones case, where the facts aren't in dispute. He said what he said, she said what she said. So it's up to the jury. I mean, the difference is, because of the Ricky Jones case, that was purely, you had to show the intent. You had to actually show that he intended people to act on that. There's no sort of reckless component to that, or objective component. So that will have been put from the jury. And if, I have no idea why juries sort of make decisions. The juries might have just sort of said, you know what, it's a free speech issue. I either agree with him, so it should be allowed to say it. I don't agree with him, but I would fight to the death his right to do this. His right to say that. Or they might just say, yeah, this was clearly just some guy spouting off in the street. Because at the end of the day, the fact is that with regards to the Lucy Connolly thing, people were burning down hotels, whereas with regards to the Ricky Jones thing, nobody was actually going out cutting people's throats. So that might have, played a factor there. But yeah, so that's why she was appointed. I personally would have advised her and said, look, I think we can run on this. Bit of sympathy. I mean, like I say, technically it's an objective thing, but apparently you only need to get 3 people on board to get your mistrial and your retrial. Okay, so there would be a retrial, but you could try again. I mean, they always say the second barrel is usually fatal when it comes to retrials, but it's worth a punt, and they only usually do 2 retrials. I mean, like I say, theoretically, there's nothing constitutionally to stop them having as many goes at potting you as they want, but generally speaking, the prosecution CPS only ever try twice. I mean, I can think of only a handful of examples where they've gone for a third attempt. So I would have punted it, and I would have used the old Mark Twain quote. I have never wished death upon anybody, but I've read quite a few obituaries with pleasure, because you've got the "for all I care." And also, I would have argued, was actually anything stirred up? Because you've got to look at the context. Did anybody reading that tweet, so I'm sort of almost doing my jury speech here, members of the jury, clearly there are a lot of people out there who share this woman's opinions. However, and I do know, yes, they're terrible opinions and they're vile, but she's not on trial for being a nasty person. She's being on trial for did her actions make the situation worse? Because that's ultimately it. Did it stir up racial hatred? Did it actually add? So I would say there's loads of racial hatred out there. We can just see it. So did her actions make that any worse? And I would argue and say, look, people are either going to read it and agree with it, or they're going to read it and either disagree with her strongly, or it might even be, does it the other way? Well, even if I disagree with immigration and stuff, I don't think you should be saying this about people, and this is all horrible. But ultimately, is somebody who stands there sort of going, refugees welcome, are they realistically going to, I've always been quite, against sort of burning people, but having seen her tweet, you know what? I do think actually it's a good idea. I mean, I would have done it like that almost on the ridiculousness. Now, whether or not that would have worked, I don't know. But when you're looking at those sort of sentences, 3 years plus, it was worth a punt. But the other issue is the bail issue. And I have to say, I was very surprised that didn't feature, because the other thing to do is, but this is more a PR thing, not a legal thing, so you couldn't advise somebody to do this, but maybe have the second bail attempt, and when you get it, just say, okay, I'll plead guilty, but get all your PR people out there, because I'm sure there would have been people willing to do it, just saying, I'm not guilty, but it's been told to me that I'll spend longer in prison if I fight this than I will if I just plead to it. Just sell the narrative, because like I say, ultimately we just deal with the legal stuff, and we're not supposed to look at the wider context. And I think that's quite right. We try every case on its own merits, and you don't want to make them referenda on wider issues. Like the O.J. Simpson trial, I mean, that was just effectively a referendum on the LAPD. Although having said that, I do think, because that was a terrible way to prosecute, that was such a badly prosecuted case, that was the only correct verdict on the evidence anyway, because the prosecution made a complete ass of it. But that, so that's it. But like I say, I'm happy to discuss this further. Be very interested in your comments. But like I say, I just think it's about the misunderstanding stuff. So, is there any idea that people were lent on? Well, no. The sentencing guidelines, she was sentenced in accordance with the ones. And as I keep pointing out, the public are allowed to to comment on sentencing guidelines. They take input from anybody who is, has an interest in this, and obviously that includes the wider public. So feel free to write to the Sentencing Council. I mean, sometimes they put up consultations, but you can also just, raise issues generally, and they will be considered. So the fact is, I do find it interesting that nobody really cared about these sort of offences after 2011. It was all, lock them up, they're all yobos, because, people were getting sort of like multi-length sentences for shoplifting bottles of water, but they said it's during a public disturbance. So, that the context makes it worse. So you might have committed an offence not in a sort of hot situation, when there's a lot of public disorder, and you'll just get a slap on the wrist. But if you do it when there is rioting going on, you'll go inside for years. I mean, it's always interesting as well, because I think, as I've said before, the big driving thing is the weather. Nobody ever riots when it's raining or in winter. Have you noticed that? It's always when it's hot summers. So there's all sorts of factors there. So yeah, I personally, I would have, because ultimately it's the client's decision. You just say, here's the various options, the various risk factors, and what might happen, with various outcomes, but you have to leave it to them. And she seemed quite adamant. It's really strange this. She was adamant that she just wanted to plead guilty to the offence as charged. She didn't even want a basis of plea put in. It was quite correct for the solicitor to say there is a risk if this goes to a Newton hearing, you'll lose some credit. But I wouldn't have lent on and said, I think it's worth the risk. It's ultimately up to you, but I do actually think it was worth the risk. But there's no suggestion, people say, the judge was clearly lent on. It's well, what's the evidence for that? The judge sentenced in accordance with the guidelines. The bail aspect, I mean, I do think she might have had a punt at bail, because, like I say, there's a presumption of bail, especially if, and she was told, the jury were told she was a person of good character. And you can only really, refuse bail if risk of absconding, risk of interfering with witnesses, or risk of committing further offences. I mean, she had all the classic family ties, local connections. She's got a child. She's not going to spend disappear to Northern Cyprus. She's not going to spend the rest of her life looking over her shoulder. Interfere with witnesses? Well, how? What witnesses? I mean, there's very little in dispute here. and commit further offences. Well, the fact is, she she took the tweet down, and once she realised the seriousness of this and what the position she was in, she very much shut up, didn't she? And I think the fact that she had quite a history of tweeting like this and then suddenly stopped, I think that would be very good evidence to say clearly this is somebody who's not going to commit further offences. So she might have actually got, I do think there's a good argument for bail. I don't know why she got knocked back. I have been trying to find the remarks on that, but I can't find them, and if I can, because that'll be very interesting. I mean, like I say, with the Ricky Jones thing, he was remanded in custody too, though. He had the same thing. He was knocked back on a couple of bail applications, but eventually he was actually bailed because there's what we call the custody time limits, where you're supposed to bring a trial on within 112 days, and obviously they didn't. So after that, it's like, okay, we have to let you go anyway. So arguably, the longest you would have sat in prison would be 112 days anyway, which, bearing in mind the outcome, might have been worth the punt. But anyway, I hope that's clarified a few things. Like I said, I'll link to the Court of Appeal decision in the description, because that goes into it and you can form your own views. And I would be very interested in what you think. And also if you've got any follow-up questions, because this is clearly quite a hot topic, I'm happy to do that. But like I say, it was just to clear up the misunderstandings, because there seems to be quite a lot of it going around, especially on social media. But there you go. As always, hope you found that vaguely interesting, vaguely informative. And I do think it was reasonably accurate this time, because I've literally got all the paperwork in front of me and I was reading it.